Okay, then I can set that up on mine really easily. Do you want me, have we called the meeting to order?
Not yet, I'll be with you in just a second.
Yeah, you can put it on the flash drive.
Okay. The December meeting of the Belmont Board of Adjustment will come to order. Looking here, we don't have any minutes from the last meeting that we have to approve, do we?
I
don't see it on the agenda.
They're not on the agenda, we are still working on them.
Okay.
Based on the training and.
All right. Chair will entertain a motion to set the agenda as modified. Everybody should have a copy of the modified agenda.
So moved.
Second? Second. All in favor, aye. Motion's approved. Next thing is the training to be held, as we'll talk about the schedule later.
Thank you, Mr. Chairman.
Yes.
We have our attorney with us tonight, Marshall Walker with Gray, Layton, Kirsch, Solomon, and Smith, for further training. We had training earlier this year.
Yes.
We hope that we all are always learning.
Indeed. And this is timely in the event that we haven't had sufficient training on appeals, so we look forward to this particular session. Thank you, sir. Good evening.
Can I ask a quick technical question? Is Open Belmont the right network? Does that work?
There's a 2-something-G and a 5G.
But it's Open
Oh,
Belmont
no,
is
that's
the network name, or?
exceedingly slow.
Oh, there's not another one for you guys?
Yeah.
Okay.
Jamie might coax it.
Appreciate it.
All right, everyone. Good to see everybody. So the goal here, and I looked through, I saw your training from earlier this year. I'm gonna go over some of those, a lot of those general points, but also some more specific things.
Good.
Particularly about findings. I want to talk a little bit about certain facts that would be relevant to the hardship determination, and maybe some more detail than you guys have gotten previously.
Will you be addressing appeals tonight as well, sir?
I will talk about it just briefly,
Okay.
but not in a lot of detail. Do we have an appeal pending?
We do not believe the appeals may be coming back. It's unclear at this time. We have 2 applications, or 2 appeals filed that we don't know will move forward or not.
Okay, sure.
Are those from the summer?
Yes, sir.
But that's a different avenue. Obviously, any appeal of our decision would have to go to the Superior Court.
That's correct, and that timeline has passed based on the variances that the approval dates and the appeal period has passed, so it would not be appeal of the decision of the variances that would be coming back.
Yeah, and so I'll just start right there, and I didn't do a slide on this, but, you know, the 2 types of hearings that you guys are going to have are variances, which by far are the most common. Then you have appeals from decisions from the planning director or planning director staff, and this would include any kind of binding order, interpretation, et cetera, of an ordinance. So that's less common. The appeal process, or that appeal branch of decisions, is really broad. But again, most of the time you guys are going to have variance issues.
Well,
So-
if I can
Sure.
ask you about this thing, because we were talking about this potential appeals that are coming up. As I read the document here, it says that there should be no ex parte communication regarding variances, and it seems that also applies to appeals. Is that correct?
That would apply to everything.
Everything.
Yeah.
So,
Sure.
if these, there's a potential that this board may have to have a discussion or hear an appeal about something we have already decided. So we're very familiar, and we have discussed among ourselves the issue on which the appeal would be submitted.
I'm not sure it would be submitted on that issue, because otherwise it would be duplicative, it would be redundant. Would this be an appeal of the planning director's decision that they?
That's correct. The appeals are based on the planning director's interpretation.
That a variance
of
was
the
needed.
ordinance, not in the variance section of really a code enforcement and how we remedy code enforcement cases. So they're looking at that. So it's not relevant to the variance decision made by this board.
Yeah, so I understand
Yeah.
your question is,
The two seem to be linked very
they are,
closely.
you could say that they are related, but they are different. Okay.
I appreciate the difference.
Yeah.
My concern is the mindset of this board with regard to the fact that we've already discussed this. But I understand what we would
Well,
be.
there's no problem with you having decided the variance and then
Right.
deciding the appeal, so
Right.
I don't
Okay,
think there's any problem with that.
okay.
And as far as ex parte communications, what that is referring to is, you're not supposed to have communications with the applicant, outside the hearing, you're not supposed to have communications with, other, witnesses outside the hearing.
Okay.
You having decided this prior.
Right.
Or the variance prior is not an issue.
Got it, thank you.
So, and this sort of brings to the first point here is, as you guys know, you're a quasi-judicial body. You're similar to a judge, and as part of this process, the important thing to remember is that the applicant has certain due process rights. That includes notice. It includes required recusal in certain circumstances, and that could be because you have some relationship to the applicant, you have some financial interest in the outcome of the variance request for whatever reason. Don't expect that to come up very much, but it's important to keep those in mind, because if a recusal was required on those kind of bases and there wasn't a recusal, that would certainly be grounds to reverse any kind of determination. That's a pretty, easy one if you're appealing, because that's going to be a due process violation for the applicant.
There's also due process interest in us following our own procedures.
That's correct. So
Yes.
you're talking about procedural due process.
Right.
I'll get to that.
Okay.
It's important that the procedures be followed, and that's really what I'm at the hearings to help you do, to make sure that you are following your procedure, you are, crossing your T's and dotting your I's. I'm not there to help you make the decision,
Understood.
but from a procedural aspect, I will try to help you along.
So the ex parte communication also means we're not supposed to talk about the case to each other or amongst ourselves
You shouldn't
prior to the public hearing, right?
Yeah, you shouldn't discuss the hearing and the
The
issue,
case, right,
the
right,
case
right.
outside of, and that doesn't really go to ex parte, but that goes more to the, in my opinion, the open meetings
Right,
kind of
right.
issue. You don't want to have discussions and anything be construed as a meeting about a case.
But we can discuss procedural operations or logistics for,
Yeah.
like,
Yes.
yeah, okay.
I mean, that's when that's what we're talking about now. We're talking
Gotcha.
about this kind of thing. But I would refrain from discussing a specific case, outside of the the actual hearing itself.
Does that include consulting the staff if we have a question about the package that they send us on it?
If you have a question about the package,
In other words, before we get to the hearing, the staff will send us a package about what the hearing concerns, what the issues are.
what kind of question would you have in mind?
Well, I suppose there could be, something was said to be attached that's not attached, or
Clarification of where a line might be or how it would impact.
So if there's a question about
Clarifying some of the information in the package, specific information in the package.
If you think you're missing information, I think that's one thing. If it's a specific substantive thing, at the hearing, you're going to have an opportunity to
Right.
just to ask the staff about that issue at the hearing, because the staff is going to be
Okay.
a witness at the hearing.
So some of us are also on the planning and zoning board. When we get an issue that comes before the planning and zoning board, many of us will go out and scope out the issue, the zone, the area, the lot, whatever it is that is in question, to see how, what the specifics are, the width of the street,
Well, we
so on
can
and
do
so
that.
forth. We are not precluded from scoping out the actual physical area about which this appeal may be, or a variance may be brought up, are we?
You're not precluded from doing that. What I would sort of caution against is, it is the applicant's burden to
Yeah.
show the evidence and the required findings. If there is an issue that you think needs more testimony, that's something that you can
Oh, there it is right there.
that you can bring up at hearing. That's all I'll say about it. It's just
Okay, good.
just keep that in mind. It's the
Yeah.
applicant's burden.
All right, good.
You don't have to dredge up evidence or
Right,
for or
right.
against for the applicant.
Well, sorry, but this came up at the last one.
Sure.
You know, what about cases? Law, not facts, but law. If we're deciding whether something constitutes a substantial hardship, and there happens to be a case, and I say this because I'm a lawyer, so I can find cases if I'm so inclined, that, it's legal, it's not factual, but we're concerned whether something's a substantial hardship or not, and here's a case with a similar situation that says it was a substantial hardship. Are we allowed to bring that
Offer
to
that.
bear? Not necessarily that it's binding, obviously, it's not precedential, but that, well, we're concerned that this isn't really a substantial hardship. Well, here's a situation that's similar where a court said that it was, so that has some relevance, I would think.
I mean, I think you're entitled to, look at the law, make sure you follow the law.
That's what, because if there was something that I found in a case that said, this was an error of law reversed, I just think it would be silly to not be able to consider that and head down a path where we're going to end up getting reversed.
So we'll talk about some specific things that constitute hardship and what what doesn't, and this is under case law. But anytime you're looking at case law, and I know you appreciate this, you just want to be careful, because remember, you are deciding all of these cases on their own facts.
Mhm.
So you got to be really careful, because even these cases, there are differences,
Mhm.
and in the cases themselves, they'll go out of their way to distinguish the cases based on some specific fact. So that's the thing to keep in mind.
Oh, yeah.
In the instance that Jim just brought up, one would think that if this person is represented by legal counsel, that the legal counsel would present that, okay? But if not, if it is known to us because we adjudicated a similar situation in the past, or because we have a person who is somewhat more familiar with the law than any of the rest of us, it seems to me it would be not inappropriate for him to raise that and bring it to the rest of our knowledge for consideration. Is that correct?
So I don't have a problem with that. I think,
Okay, good.
I think I would be, but remember,
Each one's different.
Yeah.
each one's different.
I mean, we
This is-
certainly-
You're not, there are very few circumstances where there's going to be something that is directly on point,
Right.
and it's gonna be, you know, that kind of issue.
Right.
I know it came up with the turret case
Yeah.
this summer, and I'm actually gonna talk about that case, but you just have to be careful about that. There are certain clear legal principles about hardship that I think you guys should follow, but be careful about applying specific cases, okay?
I mean, certainly you can't say, well, because this case said this, therefore we have to do
Right.
this same thing. Obviously, there's,
Right.
you know, but it can be relevant.
And you may want to, I mean, if the applicant is represented by an attorney, if there are certain questions that you have about the law and about hardship that's raised in a case, you know, you may not want to ask them specifically about the case, they may not know about the case, but you may
Yeah.
ask them, well, you know.
And I forget what, I mean, I'm not going to go out and,
Sure.
I think it was because we were looking at this handbook.
Right.
And in reviewing the handbook, there are case cites
Right.
and some of the footnotes. And I was curious about one, and that's why I went
Right,
on
I mean,
Westlaw and looked it
and that's
up.
all there to assist you guys with what the law is. So, just continuing on, obviously there's an evidentiary hearing. It's important to make sure all the testimony is presented under oath, including the staff. One thing that comes up sometimes, but not every time, is that it's important to remember that the applicant has a right to cross-examine. They have a right to even cross-examine the staff. You know, particularly if they have an attorney, the attorney should be aware of that. I think it might be a good practice to just, after someone testifies, to ask the applicant, and I don't know if you guys do this or not.
I think we do.
To just say, do you have any questions for the witness? Just to make sure,
Sorry.
you're fine. Just to make sure that there's no issues with that and that they are entitled to ask questions if they want to.
I think we do that.
Okay, so as a quasi-judicial body,
Trying to turn
you
this
guys
thing
are,
off.
you guys are fact-finding,
I got it.
and you're applying the facts to the applicable standards with the variance. We're talking about variance here. You guys have to determine contested facts. If there are contested facts, they have to be determined. They should be reflected in your written decision. And the language of the statute, the decision must be based on competent material and substantial evidence in the record. So it's important to make sure that there is that, you know, that evidence reflected in your decision. Decision has to be in writing. You know, this came up, we talked about this, you know, with the decision over the summer. And the decision in writing should reflect the determination of those contested facts and their application to the standards. The decision, the order form that you guys have now has those factors listed, and then below that, you need to, it's very, very important to list the specific facts that you guys have gotten from the evidence and from the record, and their application to each specific standard. Decision has to be signed by the chair or the duly authorized, or another duly authorized board member. It's important to remember that even though you're voting at the hearing, your decision is not effective. It's not an effective decision until it is in writing and it's filed with the clerk. Right in writing, signed, filed with the clerk.
I'm sorry, so how does that happen? So we have these evidence worksheets that we fill out individually, and then what happens? Does the chair then take, we usually hand it to the staff, right? And then the chair submits the decision in an email to the staff, and then staff issues it to the clerk?
I think, well, if I'm, we deliberate. These are our notes. They're not official, but we vote and we set out our reasons in the vote. The secretary of the board is taking notes, the minutes.
She
Types up.
Okay.
He signs it. We give it to the clerk, and that's what starts the clock running.
Okay.
Right, that's correct. So, but we do, what's important, and it helps us with the minutes as well, is when
Collect
you're
those sheets.
deliberating and you're voting on each finding one at a time, that if it's support, you're using your evidence that you've written down.
In other words, I think this factor is met because A, B, and
You
C.
go over that, and then what you do at the end of the meeting, after the case has been decided, you turn in the sheets to the secretary, and that helps us create the order, we go back, we listen to the tape.
So we verbalize it, we hand you the red
Verbalize it, you give
worksheet.
us the details, and we make sure it gets in there.
Okay.
When did, I'm an old man, I forget things. When did you join us?
Ah,
You were referring
Early
to a
summer?
case this summer, when?
which one was that? Well, my first case was
The one where
The
they built.
various cases and.
So my first case was the case of the couple who bought the property. They couldn't do the water sewer connection
yeah,
directly
yeah,
to
yeah.
the
Okay,
street.
so,
That was back in
Oh,
May.
that one, before,
Okay.
yeah.
Yeah.
all right,
And
so very good.
I was here for the more challenging one over the summer.
And
too.
so just to echo the staff, yes, it's important to keep your notes. So in talking to David, and just for your guys' guidance, those notes, we don't take the position that they're not part of the record, they're not admitted. So
Okay.
those are, it's like as if, you go to a court hearing, the judge is going to keep certain notes, but those aren't necessarily part of the record or never part of the record. So that is just your, the facts that you're writing down. You're presumably going to voice those facts at the hearing,
Okay,
and that's just to help the staff.
okay. I just didn't know how the whole process went down, so
It's all right.
after we hand these worksheets over.
So, and the last thing there, the decision must be made within a reasonable time. After the hearing is what the statute says. The ordinance, it should say 31 days pursuant to ordinance. That is what the local ordinance requires, is 31 days. So that's the time frame you guys should be operating on between having the hearing, closing the hearing, and then having the written decision signed and filed with the clerk.
And we don't have like a vice chair or something, right? Because we're like a 4/5 quorum. There's no like other authorized person.
Well,
Right.
We have the board has a chair and the vice chair.
Oh, who's the vice chair? I'm just curious. Oh, okay,
Oh,
okay.
I think that only matters if the chair isn't
The chair is
here.
not present.
If he's not present or he's unavailable, that's where that would.
Can we make a decision if one of us is absent?
Yes.
Oh.
But,
it's before, on a variance, it's before fifths.
so that would mean everyone would
And
have
if I
to.
were
I
absent,
see.
or
Four
any
of
one of
us
us
would
was
all
absent.
Because that actually happened before you
You guys
joined.
are you're covering my material.
Oh, okay, okay.
Because Neil was absent and
No,
there
I'm
were
glad you guys-
four of us
I'm
and
glad
it had
you
to be
guys are on top
unanimous.
of it. So I want to stress the importance of the written findings. So I've got a case site here. It's a Shones versus Board of Adjustment. It's a 1995 case from the North Carolina Court of Appeals, and it involved the Asheville Board of Adjustment. And the Board of Adjustment written decision only included a single fact determination regarding the application. It's had one sentence about the application under one of the factors, but it didn't have anything else. And otherwise, it only recited the specific four standards in
Guidelines.
conclusory fashion. It said, yes, it did or did not,
Yeah.
meet those standards, and that's it.
It didn't explain why it did.
Did not explain why. And the Court of Appeals reversed the Board of Adjustment there.
Yeah.
And what the Court of Appeals said is, findings of fact provide a safeguard against arbitrary action by the Board of Adjustment by providing a sufficient record upon which this court can review the board's decision. That's what your written record is for. It's for judicial review, and it's to make sure that you guys are applying the facts as you're supposed to the different standards. And the Court of Appeals went on to say, the board was required to state the basic facts on which it relied with sufficient specificity to inform the parties, as well as the court, what induced its decision. Can't rely on findings of fact which are conclusory in form, okay? So, you guys are very familiar with these, but we're going to talk about the hardship in more detail, so I want to set these out. You guys know the four findings that are all required. And the first three are hardship related. The fourth one, which we'll talk about separately, is admittedly a kind of wishy-washy, squishy standard, but we'll talk about it. So what is unnecessary hardship? What does that mean? Well, you're not required to show that no reasonable use can be made of the property. That used to be the standard. It's no longer the standard. It's been taken out. Cost alone is not an unnecessary hardship. So any kind of monetary, financial burden, that by itself is not a necessary hardship. However, the person can show that that they can show the substantial and undue nature of the additional cost as compared to others with the same restriction. So they can show that, well, because of some issue with their property, and it sort of morphs into the other factors, that their cost is more substantial and there's more of an undue burden to that person. Can't use personal circumstances. So this sort of works in the reverse. You can't deny a variance because the applicant's really rich and can afford the extra cost. That goes without saying. Any kind of things not related to the property, personal circumstances, and the focus should be on the property, location, size, topography. So it's not a necessary hardship if the conditions are common in the neighborhood. So if you think about the factors, one of the factors is, the size of the lot or the shape of the lot. But if all the lots are similarly oddly shaped in the neighborhood, that's not going to meet that factor. Okay? Additionally, with this factor related to sort of what I would call the self-created hardship, purchasing a property with knowledge, that's not a self-created hardship. The new property owner is deemed to have the same property rights as the prior property owner. So I think the self-created hardship is maybe the one that has sort of the most examples, and I think can get a little confusing, so we're going to talk about some of those. So some examples that are self-created hardship. If a person owns a piece of property, and say they sell a portion of that property, they sell off an odd sliver of the property, and now they've got a problem because their property is oddly shaped. Because of the setback or whatever, another ordinance, they can't properly build. That might be a self-created hardship. That could be. Because, and that's different than them buying the property as is. They already owned it, and they did it themselves. They parceled part of it off and sold part of it, and they created and made the property have that issue. It could also be a self-created hardship if an applicant failed to follow either zoning procedures or failed to obtain a building permit before beginning construction. There's case law on that point where someone failed to obtain a building permit, they went ahead and built anyway, and they built in the setback. Self-created hardship.
Or they used the wrong diagram. That's called shooting yourself in the foot.
Yeah, that's literally what some articles say. You can't shoot yourself in the foot. So let's talk about a case example here. And these are the facts. Owners hire a licensed surveyor to conduct a survey prior to construction. Owners submit the survey to the city and obtain a building permit. Neighbor notices that construction did not comply with the setback requirements. Neighbor tattles to the city and submits a survey showing something different than the owner's survey. Owners apply for a variance and neighbor opposes. Is this a self-created hardship by the owners? What do you guys think?
I think it isn't, but that's just because if I'm remembering, that's the case I brought to the meeting last time.
Neighbor notices that the construction.
And I didn't think it was.
Under the strict requirements. With the setback requirements. Licensed survey to kind of
You understand the issue?
Yeah.
So what happened is, the owner gets a licensed surveyor to do a survey.
Yeah.
That survey is wrong, and they start construction. The neighbor finds out about it, and goes and tells the city. City gets involved. They realize they have a problem because they've built into the setback.
That's not a self. I don't think.
I think they're entitled to rely on.
I don't think it's a self-created hardship.
All right. Yes, you're right. So the court of appeals said no. Good faith reliance on a survey from a licensed surveyor is not a self-created hardship. So that is a sort of what I would say is a pretty clear principle from the court of appeals. And if you have a survey, you do what you're supposed to do, and the licensed surveyor just gets it wrong, particularly for the owner, that is not a self-created hardship. So let's talk about this. Before we talk about this one, there's one other thing I want to mention about sort of where hardship, if it's personal in nature, the hardship was caused by personal circumstances. That can be more than just what's sort of obviously personal. There was a situation, a court of appeals case, where the court basically said there was a self-created hardship because an owner built a fence on their property. They built it 8 feet. It was supposed to be 5 feet pursuant to the ordinance. And they built this fence all the way across.
You talking about the height of the fence?
I'm talking about the height.
Okay.
And they built it all the way across their property. Well, the Court of Appeals affirmed a Board of Adjustment who said that it was personal because the owner of the property built the fence and they built it too high because basically they hated their neighbor. So it was like a spite fence, and they said that was personal. They created their own. That it was self-created, but it was also personal in nature because the reason that they built the fence to begin with was because of a dispute with their neighbor. Okay, and I mentioned that just because I think it's.
And how was that found?
The Board of Adjustment denied the variance, and the Court of Appeals affirmed. And that was a Mecklenburg County case.
Got it.
Okay, so let's talk about this final factor here. Ordinance purpose, public safety, and substantial justice. So the way it's phrased, the requested variance must be consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice is achieved. What does that mean? So for starters, when you talk about consistent with the purpose and intent of the ordinance, if the ordinance itself in its language expresses a clear intent, the variance cannot undermine that intent.
Wouldn't that be nice? But they seldom do.
They seldom do. They almost never do. But that's what that refers to. So that's when this one would be, for instance, denied or would fail if the ordinance says, the purpose of this is, X, and they're requesting a variance to do that. So something just to keep in mind. Variance cannot negatively impact public safety.
Now, that ordinance applies both to, well, it applies to the code as well, right? You're talking about the ordinance, you're talking about the code.
Usually when they're talking about that, they're talking about the specific ordinance at issue. Now, if there is language elsewhere, like in the general sort of code, that could be relevant here as well, I think.
Well, so what do we got? We got the,
So you're talking about the zoning ordinance, when you're saying the
Yes.
ordinance. So
Well,
that,
yes.
we refer to that as the Belmont Code, so it's the same thing.
okay.
Yes.
The ordinance is the same as our land development.
Okay.
Land development
Book
code.
Of ordinance.
Code and
And
house.
I'm sorry, I misunderstood your question. When I'm saying ordinance is just generally what it is, but it's still, yes, it's the code.
All right, thank you.
Sorry for.
No, I didn't phrase it clearly. Go ahead.
So, variance cannot negatively impact public safety. So that same case that I was talked about on the personal circumstances where the person just disliked their neighbor, so they threw up an 8-foot fence, they never have to see him. That one also failed on this last factor. And the reason it failed is because the fence went all the way to the end of the property, and it created visibility problems. There was a curve right near the fence, and you couldn't see traffic. So those are things to keep in mind. The variance cannot negatively impact public safety. This is a situation where, in most of these situations, when you're talking about public safety, it's not required, but there might be, some kind of testimony from someone who's done a traffic pattern analysis or something like that.
But it would need to be an expert. I mean, we tend to get in some of these, and maybe it's more with the planning board, but there's a lot of people that come in, Joe from the neighborhood or Jenny from the block, they say, well, when this happens, all this traffic's gonna come and people, well, you can't, that's not expert opinion, that's just their random opinion, they've got no support for it.
Well, someone speculating about traffic is
Yeah.
different than like a traffic
Like
analysis.
an expert witness,
Right.
is what you're saying.
But there are plenty of
Maybe-
people that like to speculate about traffic that aren't experts, and that's
But
what,
aren't like traffic engineers.
right.
Well, I think, so when you're talking about like traffic patterns on something that hasn't happened, then yeah, you're probably gonna need an expert to flush that out. Here though, there wasn't an expert and wasn't really needed to be an expert
Well,
because the
yeah.
fence was already built. And anyone out there seeing it,
Site train.
yeah, could see that there's visibility.
Can you give another example of public safety that doesn't apply to just the vision of some structure or building? Perhaps somebody putting a septic tank in that would,
One of the points.
Blocking lights, maybe.
One of the
for-
points in that last one was about the driveway was being too short and the car wouldn't fit. It hung over the sidewalk, so you couldn't go around the sidewalk, you couldn't see somebody behind it, something like that.
Yeah, so that would be an example.
again, that's
Yeah, that's
visibility.
a good
It's
example.
mostly visibility.
Okay, well, I kind
Occasionally
of thought
it's-
it was, but I was just curious.
The other thing you see is with traffic pattern, increased traffic, but those are usually supported by expert opinion, like I said.
You should have gone with the hedge instead of fence.
Well, yeah. So this last part, substantial justice. So that is essentially a fairness inquiry. And it's important that in deciding these cases that you consider the fairness for the applicant as well as the neighbors and community. And so one thing to consider in this factor and just generally is how would this variance affect the neighbors? How would it affect, the community? If, you have testimony from the neighbors that say, if you grant this, it's going to negatively affect me for some reason, that's something to consider under this factor, okay?
But again, that would have to be based on like things that they could perceive, we also get, if they just get up there and say, well, I think if you do this, my property values are gonna go down. I mean, what's the support for that?
Well, I think,
If they're not an expert, if they're not an appraiser?
Well, they would have to bring in a couple of people in the business to suggest that some data for us to consider other than somebody's opinion.
well, I think that's where it gets, I think
Yeah.
that's where, this is where your job is. Your job is to weigh the testimony, consider it, and, if they're, you don't have to show that if you think that, certain testimony either lacks credibility or lacks weight for some reason like that, that's up to you to decide that. So just something to keep in mind. Fairness to the applicant. So I want to be careful about how I say this because David and I preach to you guys that you don't have precedent really with the Board of Adjustment. We say, don't base your decision on other cases. However, in this sort of substantial justice, this is not something that's flushed out in cases or anything like that. But some of the commentary on it suggests that the board should at least consider that. And when I say that is, if, Joe Smith or whoever, from a neighborhood, say there's two lots in a neighborhood, they sort of have identical issues. And one year, one of the owners comes and he requests a variance. He gets the variance. Okay. Say there's another very similar situation in the same neighborhood. It's something to consider whether or not it would be fair to the second applicant to deny the variance. That being said, and I told you I want to be very careful about this, you still have to look at the facts as it pertains to that case and make sure that each case meets the factors on its own merits. This is a sort of a minor point. Usually hardship is the big issue here. Just something to consider, okay?
It's the judgment of the panel. just comes into your judgment, right?
That's right. So, just a couple of to-dos for hearing we talked about. Listen carefully, take notes, that's a big thing, use your forms, and as you're listening, really think about, as you're hearing things, is that related, which factor would that be related to? Is it related to a factor, or is it just irrelevant? If you think it's related to a factor, write it down. So that's what those forms are for. Be sure to ask questions if you feel like something said you don't understand, or you think that maybe you did or didn't hear testimony relevant. Follow up with a question. If you're hearing someone talk about, this hardship, but they're not talking about if there's any specific issue with the property, ask them, is there something about the property that is, peculiar or unique? Is there some problem with the size? Just ask them those questions so that those issues are fleshed out for the record. You don't have to. You're not there to help the applicant, but you want to make sure that
Gets a fair shake.
correct.
That they understand that they got a fair shake, whether we rule in their favor or not.
Yeah, so that's really important. I mean, I think it's their job, like we just talked about. It's their job to present the evidence and present evidence that meets the required findings. But it's also your job is to make sure that you've fleshed out everything that needs to be fleshed out in enough detail. Okay. Last thing, we talked about this. Be mindful of the procedural aspects. I'll help you with this, and you guys have done a pretty good job with the hearing and doing that. So, voting. So we talked about this too. 4/5 vote required to grant a variance. As you guys talked about and picked up on, if one member recuses or is absent, then the vote has to be unanimous. Be 4-4, 3-3.
Will 3-3 pass? This board?
I think
3 is a quorum.
it's a quorum.
Yes.
Yeah.
If there were 2 of us absent, 3 could conduct the meeting and vote on it.
Okay.
But it'd have to be unanimous.
But it would have to be unanimous.
Jenna,
80%.
80% of 3, 2.4.
Can't get there from here.
Yeah.
We've had this discussion.
I thought we had to have at least 4
two-
Have 4.
Yeah. Huh?
To be-
No.
No. Actually, the staff. So I'm sorry. The staff is correct about that. The statute doesn't say it, but
Yeah.
the local code does say that you need 4. So you have to have at least 4.
Yeah, we've had this.
Thanks.
Oh, wow.
A variance, 3.
3 can have a meeting, but
You can have
4.
a meeting,
But
but
they don't
3,
have a full
but
vote.
the case really can't be heard.
Yeah, I think it says somewhere that you have to have 4 votes.
It
for
says
a variance.
4/5.
But somewhere else it says 4.
The staff is correct, and there is something in the local code too.
Okay.
The thing about variances and board of adjustments is that you have the statute, and the statute, North Carolina state statute dictates, but the code also has to be followed to the.
Okay.
It's in its supplements or.
So long as it's consistent with the statute, it doesn't contradict, it should be followed as well.
Yeah, we did have this discussion, as I recall, but the word, and we changed the wording in the document too, did we not?
The rules of procedure
Yeah.
to make sure that it's clear.
Okay.
Yeah.
Thank you for that.
Yes.
So, and you guys do this every hearing, but important to do separate voting for each required factor. If all passes with a 4/5 vote, variance should be granted. Keep going, even if a required finding fails. And the reason for that is,
For appeal purposes.
well, yeah, you have judicial review, but if you stop, then that's the only factor that's going to be looked at. If you keep going, and there's 3 out of 4 factors that were denied, then on appeal, the applicant is going to have to show that you were incorrect about all 3, because it only takes 1.
And the court can say, well, you might have got 1 wrong, but since you still got 2 and 3 right, we'll affirm if you're right for any reason, so the decision's still affirmed.
Should I not have lined that out there? Where is it?
Yeah, I don't know, we'll go back and
We'll go
look.
back and look at it.
I'll go back and
Because I
look
know
at
we
it.
had a,
Yeah.
So, you don't need to hold a final vote. Usually, the chair will say something like, having the required votes, for each of the 4 factors, variance is granted or denied, okay? And you guys have done that. That's been my experience since I've started with you guys.
probably have with prompting, but I think we do it.
Yeah. Yeah, there might be something somewhere.
That's okay,
Yeah.
we got it.
Well,
You want to summarize it
Yeah.
and be
It's less-
concise, and it was denied, it's denied because we
See, I
did
think
not
it's
get,
right.
huh?
Yeah, I think we stopped doing that because I found it somewhere in there that
Yeah, exactly.
it is not necessary to make an additional motion to deny variance, and motion to approve fails to get the required variance is denied by original motion to approve variance, or alternative motion to deny easement.
All right.
Yeah.
And it's
It's just a nice summary.
And I think, and
Be clear.
I'll sort of backtrack a little bit. I think if everything passes, I think it's fine to do a final vote just approving it. But if it's denied, I would not. Because once you miss a finding, that's it. Okay?
And you, I would then state that the motion or the variance is denied because it failed to meet all 4 of the criteria. Specifically, it did not meet criteria anti-frats, whatever it is.
And so difference here on the voting, if you do hear an appeal decision from a planning director, you don't have to have 4/5 vote to,
Right, that's just majority.
it's just a majority.
Right.
So 3 out of 5.
Now, on that appeal,
Sure.
I'm reading on the pamphlet here, it talks about, when interpreting a local ordinance, the board must determine the intent of the governing board. The best way to determine it is from the text itself. So go get the law and read it. Where an ordinance is clear and unambiguous, its plain meaning will be enforced.
That's
Okay.
correct.
Sounds good.
Yeah.
Okay.
That's correct. So that is a sort of binding principle with any law, for any kind of, for you guys as well as any, judge in a court. You're supposed to, apply the law as written, if it's expressed like that.
So, for example, if someone said, the setback is 5 feet from the property line, that's pretty unambiguous. That's pretty clear. Somebody wants to appeal that, say, I'm sorry, it says right here,
But
we
what's
have
the
to enforce it.
intent, why is the setback 5 feet from the property line? That's what we're talking about with intent, and if the intent is, safety, and we can show that, well, if you make the setback 4 feet, it would still be safe, well then, that would perhaps still be consistent with the intent of the statute, but, it's seldom will the intent be expressly, it's very rare for the legislature or the governing board or whoever to say, we are enacting this because, to do this, and we really, really mean it.
Yeah, but that
Isn't the
paragraph didn't
intent
say it.
usually like character? The intent of a setback would typically be character, of
The-
a physical character of a community.
The intent is why they enacted the statute.
So, I think what I heard Neil say is that, I mean,
It-
that wasn't exactly what it said. I don't believe it talked about. You can take a look at it if you want to take a look.
Yeah, sure. It didn't say intent, that's why I underlined it, because it
Yeah.
leapt out at me and said, because I'm a black and white kind of guy.
Well, your ordinance is clear and ambiguous. Like,
No way.
It's
Figured
plain,
that out,
its
yeah.
plain meaning will be enforced. That's different than intent.
Right.
Right.
So if it says
So-
5-foot setback.
It's a 5-foot setback.
It's unambiguous and it's clear.
Right.
That-
Very
Now-
precise.
An
So,
appeal from a decision from a planning director, that can come in all forms. That, if you look at that, you can look in the local code, you can look at the statute, it's fairly broad what can be appealed. I mean, it's basically any decision, order, interpretation, the long list of things. So, it is fairly broad what can be appealed to the Board of Adjustment, based on a decision from the planning director to planning director staff.
Has this group seen many of those? I'm just curious.
Appeals?
Of the planning director.
Not since I've been here.
It only has variances.
We've addressed only variances.
There was one code violation that wound up getting worked out. That was the very first one, the
Right,
car lot
right.
with the
We've had-
streamers.
Yeah, we've had people apply, but after meeting and going over, they
They-
withdrawn.
Yeah, they met some common ground or whatever it was. Recognize correct answer when shown, whatever that was.
So that sort of concludes what I was going to go through. Is there any, you guys have asked questions sort of throughout. Is there any other questions that you guys have?
Well, that was
I'll
the
try
one-
to answer.
That was the one I had on this, this appeal business, because, and I guess the other thing is, if the staff then it has to enforce, if the staff is required to enforce a code law rule, all right, and somebody wants to appeal that, are they appealing the fact that, or are they appealing the manner in which the staff enforces the violation? In other words,
You're saying, are they appealing the code, or are they appealing the
yeah,
staff
are they
enforcement?
appealing the punishment? and-
Or the staff interpretation.
Or the type of punishment.
So let's not, if we're talking about something that might be pending, let's not get into that, because we're.
Well, just in general,
Well, I can help with that,
Yeah.
just because I've been involved in some appeals in other jurisdictions.
Okay, good.
So what I have found there, it's, when appeals have been filed, they're generally on the directors, or whether code enforcement comes up through planning, their interpretation of the code. So not every code is black and white.
Right,
like,
sure,
your
understood.
setback shall be 5 feet.
yeah.
And there's a couple of cases that I've been involved in where it says that, okay, building material can be this, or a similar
Got it.
in quality. And we said no on this one type of material. Well, they appealed our interpretation. They were trying to prove that it is. as, you know. So it's typically been based on how we've interpreted.
Got it.
And applied the
interpret.
rules.
You're gonna kill me for bringing this one up. Or, like, remember how we had that one where if you have property on the water, you have two frontages,
frontages, yeah.
you know, that you interpret that to mean that the water is a frontage, and they say,
Well-
well, it shouldn't be, you should only have one frontage.
And I think we made a suggestion that the code be changed to accommodate that, because we're in a water community.
Well, then the code got changed
Right.
in a different aspect,
Right.
not that particular
Right.
interpretation, but.
Right.
But I was just using it as an example of something that.
Yes,
Yeah.
exactly, we amended the ordinance to provide relief on waterfront lots. Yes.
So on a waterfront lot, it's not necessarily the address that establishes the street, it's not necessarily the street address that establishes the frontage.
No, it does, and that's where we were sort of, it was your partner that straightened that out, that the front, you have a front, the opposite's the rear, which is the waterfront, is the rear, that's where your rear setback goes, and then you have your sides.
So there's actually no such thing as a house with two fronts.
That's, well, you had, yeah, well, it gets complicated. You have what we call a through street, where sometimes a lot has street frontage here.
Like a
and
corner
here.
lot.
Yeah, so you have to kind of figure that out.
That's
but,
right.
It's a little more complicated, but on a waterfront lot, it was made very clear. You have a front, side, sometimes you have multiple sides, but the rear should always be opposite of the front.
Or to give the classic legal answer, it depends.
So, and
Yes.
let me go back to something we talked about earlier about, looking at case law. I would encourage you guys to look at your books, if you have a case. I don't think it's really necessary for you to go out and do specific legal research and look for like cases. Is there a case similar to this? I don't think that's really, I would sort of dissuade you from doing that. For the reasons I talked about, where you have to decide each case on its own facts. And that's part of my job, is to make sure that, and David's job, is to make sure that you guys are, applying it correctly. If you aren't, we'll do our best to sort of, see
Now,
you guys.
in the case of an appeal, where the staff then becomes one of the contested parties, if you will, or the contested party, the town lawyer, right, would he necessarily, how many lawyers are we going to have here? We're going to have you to make sure we follow all the procedural things. That the applicant's going to have a lawyer more than likely, or could. Would the staff then have a lawyer? I mean,
That would be up to the city attorney whether he.
yeah, I'm just wondering if you would think you would
get-
want to do that. You probably, I don't know whether you would on it.
Again, some of the cases I've done it elsewhere.
Yeah.
Yeah, the city staff had a separate attorney than the Board of Adjustment attorney.
Right,
Yeah.
right,
so
and then
we
the
have a lot of
applicant could have his
attorneys
attorney
at the
too.
meeting.
Okay, good. I
How-
thought that might be the
It
case.
really depends on how the city wants to
Yeah.
run it.
But never have enough attorneys.
But they could. Right, Jim. Okay.
So can we just go back to hardship? It seems like your presentation may be wrapped up, but I just wanted to have a clear understanding of what constitutes hardship. So I don't know if there are examples where the hardship ruling was, I just kind of want to understand, if cost isn't the factor, that defines unnecessary hardship. What are some examples of unnecessary hardship, I guess, is my ultimate question.
Well, I think with cost, just a pure saying this is going to cost more is not sufficient. That's all I mean by that. That doesn't mean that cost can't support hardship, particularly if the other, factors are found. I mean, I think hardship would include, could include a number of things. Cost could be is a factor there, but it's not it can't solely.
Like, I think it could be a factor, not just to say it's expensive, but like we were talking about in the last case, it would cost us, we're 1 foot or 2 feet over the setback, and we'd have to tear down the entire garage because we're like 1 foot over the setback.
Right.
That seems to be like, in proportion to what the violation was, I think you could say that would be excessive hardship if you were so inclined.
Well, another example, and this is from a previous one, is, say a builder wants to build on a lot, the lot's really, really small, and complying with the setbacks is going to cause the house to, be just sort of
Triangular or something.
triangular or something weird, yeah.
Right.
I mean, think about a situation where you have a lot that's like sort of shaped almost like a V, and you either can't build a house on it at all, or the house is going to have to be, oddly shaped and just not really livable. That's hardship. It is.
We had the one a couple years ago where the guy wanted to build the garage, and the garage had to either be rear setback or side. It couldn't be in the front, but he had an odd-shaped lot, I think, that had some topography, so it would have been very difficult.
So he couldn't have built the garage if it wasn't a
He
front
couldn't,
facing.
he
Right.
couldn't build a rear garage because it was in the lake.
Yeah.
So when staff meets with applicants that want to file a variance, the way we explain it to them is there should be a physical characteristic to the property that wouldn't allow them a constraint that wouldn't allow them to enjoy the same privileges on a lot similar size with similar zoning that didn't have those constraints. A property with steep hills topography, a lot of floodplain on it, very shaped irregular, but was unusual for the area. So we always try to talk to them about identifying that physical constraint
Yeah, the best,
on the property, is how we look at it.
the sort of classic best example is a situation where you have a piece of property and, halfway through the property, it just drops off. And you can't even use their other property, and so they might want to apply for a variance to not, for part of the setback, so they can move the house forward on the lot, so they actually build a house, whereas before they couldn't because it would be a gully.
But somebody could say you could build it on piers and it would be, a lot more expensive to change the foundation type, but maybe you could do it. So I guess that's where it gets like
Well,
weird and fuzzy for
Well, then I
me.
think you could argue what he pointed out earlier, that although financial, just general financial, but if all your neighbors can build
I see.
at a reasonable cost, but this property
I
has
see.
such a topography on it that it's going to make theirs compared to your neighbors just so much more, I think that would be that
Something you
rare
could consider.
instant.
Okay.
That's correct.
I think we've actually kind of been blessed that, the variances that we have granted to property owners, they all really made sense.
Yeah.
I mean, it was,
That's
kind
what
of no-brainers.
this comes down to.
They were just trying to better the property and better their situation to
Yeah.
no detriment of anybody else.
It's nice to see the house going up on South Point.
I did see that, yeah.
Yeah.
That, I drive by there and say, we helped that guy out.
I would still want to see this guy's garage. I wish he'd built it. That garage is going to be epic.
A lot of it's just sort of common sense. That I hate to say, like, the Supreme Court used to always say about obscenity, you know it when you see it, but you kind of, like Jay was saying, what we've granted has made sense, and so, it's applying the facts to the ordinance and to the law, so there's always going to be some, wiggle room, some areas for us to use our wisdom and our judgment and,
It's an art, not a science.
That's why we get to wear the fancy uniform and get paid the big bucks.
Yeah, it was a scientific thing that we didn't need from you
Right.
guys.
Yeah.
Okay, any other questions? Thank you, sir, very much. Appreciate the instruction. Okay, other business is to adopt the 2019 meeting calendar. Everybody had a chance to look at it? Everybody okay with it? Chair will entertain a motion to approve it. So moved, there's a second?
Second.
Okay, just one point of conversation on that is, I have noted in the past that although we have a schedule, we should really try to keep to it as best we can, but in the event there are circumstances, the staff has shown us to be flexible on those dates when needed, and we appreciate that. All in favor? Aye. Opposed? Ayes have it. Any other business to come before the Board of Adjustment?
So I'm curious, with the meeting minutes from the last meeting, that was the two cases that we denied, right? So we're sort of waiting on the minutes, and the minutes have the written decision in them, is that?
Yes.
They will have, yeah.
Yes, yes, so.
But surely that decision has already gone out.
Yes,
It's been far
the
more than 30
orders,
days.
yes, the orders and everything has gone out, and the various cases have exceeded the appeal period. So the minutes will be coming back to you.
It was probably, like 15, 20 pages?
There was quite a bit, and,
the minutes
so we're
don't
still
have to
kind of
have every
skimming over
word.
them, but we sent them to the attorney, and we reviewed them, so the orders could be written. And again, that's why it would be very helpful when doing the variance cases, that your worksheets are used and all your facts on how you're interpreting the evidence is written on there. So that helps us when we're going back and we're listening to it and we're typing up the minutes and we're working on the order for the attorney to review and to do the order, that everything's in sync. But the minutes will be looking at.
Okay, and this is sort of a weird question, but is there ever a case in an appeal to a higher court where we would be called to witness? Okay. So if we don't get, my concern is like, if we don't get those notes back, like I've already forgotten, like what I've written down and what,
Yeah, so that won't happen, so both the Superior Court, and then if it goes further than that, they're only looking at the record, and they're looking at your written order, and that's literally it, and so, and
the record being the minutes?
It would look, yeah.
Well, they can get a transcript.
Transcript, yeah,
If you
cases I've.
Yeah, if you record it, then you get a transcript. But the remedy there is often, what the court will say is, well, there weren't sufficient findings to, grant or deny this. And so they'll actually send it back to the board for further findings.
And we could very well come to the same decision, we just
And
support it better.
Mecklenburg County, either because they're the busiest one or for some other reason, they are often the subject of having to go back. So you see that a lot.
I mean, I suppose there could be, like, if there were an argument about bias or something, wouldn't there be a possibility that somebody might have to be called?
They will never, no.
Okay.
I don't anticipate that ever happening. I think, that's something that could be raised that could affect how the appellate court deals with it, but, no, because the appellate court is not.
They're seeing the case like anew, basically.
Well, no, if it's like a true appeal, you don't take testimony.
Yeah, they're not finding new evidence. So they're not asking you to testify because that'd be new evidence. So
Does that apply to the Superior Court also?
It applies to any appellate court, yes.
Okay, thank you.
Good. Any other questions or concerns?
That was a great question.
Yeah.
The typical tendency, it's gone to Superior Court, they'll file, the city gets documents, we usually have to provide a transcript of the meeting, copy of the order, and it gets handled.
But then that's the universe, like they won't.
That's it, yeah. And
No
the
one would be
decision
called
comes
to give
back
extra
us,
testimony.
Are there any terms coming up?
The
Seat terms?
terms,
Seat terms?
Mine expires in April.
Mine expires.
yeah, so,
I just saw that, I've got a letter here somewhere, but anyway, we'll
you can
take a
get
look.
the roster, let's check the rosters. I'm trying to think, it's a different schedule on our different boards, I can't, so I think yours is the end of April, and so the new seats start, I think, in May. So we would start advertising around February, so we can get the interviews and everything going, but let's. check
Jay,
the
you and I,
roster.
end of April
There you go.
2019, that's the only ones I have here on the letter that I got. But that was back in June, so some of the others came after that.
Right, so the terms are all staggered, so there should never be more than
Yeah.
2 people rolling off at any one
Right.
time, so we keep that institutional knowledge.
Right.
But you're allowed a second term, aren't you?
Yes,
Yeah.
yes, so depending if you started with taking over a term or not, you can go as far as 2.5 terms, but otherwise it's 2 3-year terms. And again, we had to stagger the terms to start, so that's
Right.
considered like a,
Right, when we first, yeah,
yeah,
1 year, 2 year, 3 year.
that's correct.
All right, Chair will entertain a motion to adjourn.
So moved.
Second?
Merry Christmas.
Merry Christmas to you all.
Merry Christmas.
Oh, yeah, thank you.
Very good.
Main Street looks very nice. Whoever